CIV3701 Civil Procedure Stage 2 Part 2 Actions. A. Pleadings. Number 1. General Overview. Number 1.1. The two sides of the argument. Of all the documents exchanged during the course of pleadings, it is probably fair to say that the two most important are, first, the particulars of claim, in which the party who is claiming relief, known as the plaintiff, sets out the details of his claim, and secondly, the plea, in which the party from whom relief is sought, known as the defendant, sets out his defense to the claim. Although there are other important documents involved in the process of pleadings, these two documents set out the main allegations put forward by each side to the dispute. When other pleadings are used, they tend to relate to these two fundamental documents. The allegations of fact made in pleadings are called averments, from the word aver, which means to state positively or to assert. Another way of referring to the making of an allegation in the context of pleadings is to plead a certain fact or set of facts. Step 1.2. The steps involved in pleadings. Number 1.2.1. The 5 basic steps. Pleadings consists of more than just the particulars of claim and the plea. To simplify matters, you can say that there are 5 main steps in a typical set of pleadings in the High Court and Magistrates' courts. Step number 1. The plaintiff sends a summons and particulars of claim, giving details to the action and what he is claiming. Step number 2. The defendant sends a notice of intention to defend, telling the plaintiff that he wishes to defend the action. Third, the defendant sends a plea in which he gives details of his defense to the plaintiff's claim. Step number 4. The plaintiff sometimes sends a replication or reply in which he responds to the new facts raised in the defendant's plea. This is quite rare. The replication may be followed by other pleadings, with odd names like rejoinder, surrejoinder, rebutter, and surrebutter, in which the parties respond in turn to the previous pleadings of the other party. But this only happens in very complicated cases. One might practice for years without ever seeing this kind of pleading. In most cases, the pleadings close after the defendant's plea or after the plaintiff's replication. And step number 5, the points at issue between the parties are clear and the pleadings close. Number 1.2.2, possible extra steps. While the 5 steps set out above are common to almost all actions, certain extra steps are possible in some cases, depending upon the specific circumstances of the particular matter. Although requests for further particulars are no longer permitted in respect of pleadings as they once were, in a very limited sense, particulars of certain documents or recordings may be obtained before close of pleadings. In certain actions, to be discussed in detail later, the plaintiff's particulars of claim consists only of a brief summary of the claim. If the defendant enters a notice of intention to defend, the plaintiff must respond by delivering a declaration, the equivalent of a full particulars of claim, to the defendant. Finally, there are a number of other steps that may be taken by either side during pleadings, but these are all related to either defective pleadings or shortcut judgments, which are discussed in detail at the end of the section dealing with pleadings. Number 2. The basic pleadings. Number 2.1. Step 1. Summons and particulars of claim. Number 2.1.1. What is a summons? Actions are commenced by way of summons. A summons is a written judicial demand issued by the registrar of a division of the High Court, the registrar of a regional magistrates' court, or the clerk of a district magistrates' court. A summons is directed at the sheriff of the court or his lawful deputy, rather than the defendant. The summons orders the sheriff to command the defendant to enter an appearance to defend by a fixed day, in order to answer the claim made by the plaintiff. In addition, it provides all sorts of information such as who the parties are, which court is involved, what the case number is, and so on. All summonses are signed by an attorney or by the plaintiff personally if he is not represented by an attorney. All summonses contain three main elements. Number 1. Citation of parties. The citation identifies the parties to the action, generally the names, addresses, and occupation of the plaintiff and defendant, if known, are required. If either party acts in any representative capacity, the summons should set forth such capacity, and if the plaintiff is a natural person, the plaintiff's gender must also be stated. And secondly, warning to defend. The defendant must be warned that he has a limited time within which to take steps to defend the action, or to take some other specified action, failing which the plaintiff may take default judgment against him. First, des indiciae. Des indiciae is the name given to the limited period of time given to the defendant during which he must enter an appearance to defend, or take some other specified action, failing which default judgment may be taken against him. And number 2, addresses for service. The defendant is warned that if he intends to defend the matter, he must give notice of his intention to both the court and the plaintiff within the period of the des indiciae. This notice should provide an address at which the defendant wishes to receive service of any further documents relating to the action. This address is usually that of the defendant's attorney and must be within 15 kilometers of the court from which the summons has been issued. And lastly, particulars of claim. The details of the plaintiff's claim are either included in the body of the summons itself or attached to it. Number 2.1.2. What are particulars of claim? The plaintiff's cause of action is set out in the particulars of claim. There are 5 aspects or elements that every set of particulars of claim should contain. 2.1.2a. Citation of parties. Each of the parties is identified by means of a citation. The citations provide the names and addresses as well as the occupation of the plaintiff and also of the defendant, if known to the plaintiff. Number 2.1.2b. Locus standi. Facts must be averred which show the plaintiff's interests in the matter. Number 2.1.2c. Jurisdiction of the court. Facts must be averred which show that the court from which the summons has been issued has jurisdiction. Depending on the ground for jurisdiction that the plaintiff relies on, for instance, the defendant's place of residence or domicile, the court's jurisdiction may be apparent from the addresses provided in the citation. In some circumstances, the magistrates' court's rules specifically require this aspect to be pleaded. Number 2.1.2d. Cause of action. This refers to the merits of the matter. The plaintiff should set out the material facts on which he bases his case, that is, the Facta Prubantia. It is important to bear in mind, however, that the identity of the parties together with locus standi and jurisdiction also form part of the cause of action in a broader sense. Number 2.1.2e. Prayer. The prayer comprises a list located at the end of the particulars, which indicates the relief that the plaintiff seeks from the court. The plaintiff may only request the relief for which a case has been made or pleaded in the main body of the particulars of claim. Number 2.1.3. Different forms of summonses. There are 3 kinds of summonses. First, a combined summons. Secondly, a simple summons. And lastly, a provisional sentence summons. The first 2 forms of summonses are provided for in High Court Rule 17 and Magistrates Court Rule 5. Rule 5 is based largely on High Court Rule 17, but contains certain additions that were previously dealt with in the former versions of the Magistrates Rules 5 and 6. Rules 17 and 5 deal with the formal and procedural aspects of summonses, such as citations, signatures, and the time in which to deliver a plea, rather than the substantive contents of the cause of action. However, High Court Rule 18 and Magistrates Court Rule 6 deal with how the substantive contents of pleadings relating to the plaintiff's cause of action or defendant's defense should be pleaded. Therefore, Rules 18 and 6 indicate the averments that need to be made in the initial pleading, namely the particulars of claim. However, certain averments used in particular situations pertaining to magistrates' courts practice are also provided for in Rule 5, such as the mandatory jurisdictional averments required in terms of Rule 5, Subsection 6. Provisional sentence summonses are provided for in terms of High Court Rule 8 and Magistrates' Courts Rule 14a, and are dealt with in Stage 4 additional procedures below. Notwithstanding our assertion above that there are three kinds of summonses, Magistrates' Courts Rule 5, Subsection 8 also makes provision for special summonses for rent in terms of Section 31 of the Magistrates' Court Act, for which a form is prescribed in Annexure 1, Form 3. Number 2.1.3a, Combined Summons. The combined summons is the most important form of summons and may be used for any kind of claim. It is mandatory to use a combined summons in the case of an unliquidated claim, such as a claim for damages or an illiquid claim such as divorce. It consists of two parts. First, the summons, which is really just a kind of notice from the plaintiff to the defendant via the sheriff telling him that action has been instituted and giving him various formal details about the matter, which are discussed in detail below. Remember that a summons is a process of court. It is issued by the registrar or clerk of the court, which basically means that the registrar checks that the formalities have been complied with, gives it a case number, opens a file, and stamps it with an official stamp. It is then served, together with the particulars of claim, by the sheriff of the court. And secondly, the particulars of claim, which are attached to the summons. The particulars of claim contain the material facts on which the plaintiff relies for his cause of action. The facts are set out in a concise and logical way in a separate annexure, with the headings particular of claim, which is attached to the summons. While the summons itself is drafted and signed by an attorney, the particulars of claim are usually drafted by an advocate and signed by both an advocate and an attorney in the High Court, and must comply with Rule 18 of the High Court and the similarly worded Rule 6 of the Magistrates' Courts, which relate to pleadings generally. The combined summons derives its name from the fact that it combines a summons and a full statement of claim in one document. 2.1.3b, Simple Summons. A simple summons is simpler than a combined summons, in that it does not have a separate particulars of claim attached to it. The particulars of claim are included in abbreviated form in the body of the simple summons itself. A simple summons may only be used for those cases in which the plaintiff's claim is for a debt or liquidated demand. In other words, where the claim is for a fixed, certain, or a certain amount or thing. Clearly, a claim for a specified amount of money owed, for example, a claim for a purchase price of goods sold and delivered, will qualify as a claim for a debt or a liquidated demand. Note, however, that such claims are not restricted to claims for a specified amount of money, but also include claims for a fixed and specified thing. For example, assume that a carpenter agrees to make a table for a dining room but fails to perform the work. A claim against the carpenter for specific performance, that is, in order that he make the table, will qualify as a claim for a debt or liquidated demand, since the claim is cut and dried. The following may also be classified under The following thing may also be classified as claims for a debt or liquidated demand: a claim for the cancellation of a sale and ejectment, an interdict, the delivery of property, and a claim for the amount due on an overdrawn account, an overdraft. However, a claim for damages is never cut and dried, and does not qualify as a claim for a debt or liquidated demand. The reason is that the amount payable for damages, the quantum of the claim, is always open to dispute. A good example would be that of damages arising out of a motor vehicle collision. If you take the damaged car to 3 different panel beaters, each will give you a different quote. This discrepancies between the quotes may be so great as to be shocking. In the absence of an agreement between the parties, this kind of debt will only be liquidated once a court has considered the evidence, decided the fair and reasonable cost of repair, and has delivered judgment to this effect. Another example of a claim that will never qualify as a claim for a debt or liquidated demand is a claim for divorce. Usually, in the case of a simple summons, both the summons and the particulars of claim are drafted and signed by an attorney. Although the particulars must disclose a cause of action, they are extremely brief and need not comply with the requirements of the High Court Rule 18 and Magistrates Courts Rule 6, which are dealt with in detail below. In fact, the word label has been used to describe the kind of particularity required, which should be enough merely to give the defendant an indication of the kind of claim being made in sufficient detail to enable him to ward off an application for summary judgment. The particulars should include sufficient facts to show that the plaintiff has locus standi and that the court has jurisdiction. Over the years, a legal shorthand has been adopted for various kinds of popular and tersely described liquid claims. For instance, goods sold and delivered, monies lent and advanced, work done and materials supplied, and professional services rendered, all at the defendant's special instance and request. It is mandatory to use a simple summons for a debt or liquidated demand in the High Court, but not in the Magistrates' Courts, where a combined summons may be used instead. There are advantages, though, to issuing a simple summons when the claim is liquid. The brevity of the particulars and the non-involvement of an advocate at this stage reduce the cost of the proceedings, and as the majority of liquid claims go undefended, it is generally useful to commence a matter that involves a liquid claim with a simple summons. However, because the particulars are so brief and usually fail to comply with the provisions of Rules 18 and 6, the filing of a declaration is required if the matter is defended. It therefore makes more sense to issue a combined summons rather than a simple summons if the plaintiff is aware that the defendant is likely to defend the action, as in the long run this will save time and costs. Although there are certain liquidated claims, such as claims based on mortgage bonds, which require fairly complex pleadings and do not lend themselves to the manner in which simple summonses are customarily drafted. Furthermore, the danger exists, particularly with regard to complex claims, that an attorney who does not take full instructions may draft a fairly standard set of particulars, making certain assumptions in the process. These assumptions may prove to be false in the light of more detailed instructions, obtained for the purpose of drafting the declaration after an appearance to defend has been received. The result will be a simple summons that differs in a material manner from the declaration. The main differences between a simple summons and a combined summons in the High Court may be summarized as follows. First, a simple summons is used only when claiming a debt or liquidated demand, whereas a combined summons may be used for any claim. Secondly, the cause of action is summarized in a simple summons, and the abbreviated particulars of the claim included in the summons need not comply with Rule 18 of the High Court or Rule 6 of the Magistrates' Courts, whereas with a combined summons the cause of action is set out in full in the separate particulars of claim, which are annexed to a combined summons, which must comply with High Court Rule 18 or Magistrates' Courts Rule number 6. Thirdly, a simple summons is followed by a document known as a declaration once the defendant enters an appearance to defend. The declaration looks like the particulars of claim attached to a combined summons and must comply with Rule 18 or Rule 6. And fourthly, a simple summons must be signed by an attorney who acts for the plaintiff. A combined summons in the High Court, however, must be signed by both the attorney and the advocate who act for the plaintiff. Number 2.1.3 C. Provisional Sentence Summons. A provisional sentence summons is used for those special cases where the plaintiff's claim is founded on a liquid document such as a check, a mortgage bond, or an acknowledgement of debt. The provisional sentence procedure is dealt with in later detail in the book, and therefore this form of summons will not be dealt with here. Number 2.1.4 Drafting a Summons. Rule 17 of the High Court Rules and Rule 5 of the Magistrates Court's Rules provide specific and detailed instructions for the contents of a summons. Number 2.1.4a High Court Rule 17, Subsection 1a and Magistrates Court's Rule 5, Subsection 1a. Dis indiciae. The summons must inform the defendant that he wishes to defend. He must give notice of his intention to defend to the plaintiff within a certain number of days. The time limit is usually 10 days, but this will be discussed in more detail below. Number 2.1.4b. High Court Rule 17, Subsection 1b and Magistrates Court's Rule 5, Subsection 1b. Warning to defend. With a combined summons, the summons must inform the defendant that within 20 court days of delivering a notice of intention to defend, he must take his step in the action. The defendant's next step will be a plea, or an exception, or an application to strike out. These steps will be discussed further in due course. Number 2.1.4 C. High Court Rule 17, Subsection 2 and Magistrates Court's Rule 5, Subsection 2. Appearance of document. High Court Form 9 and Magistrates Court's Form 2b set out what a simple summons should look like, and the details it should contain. High Court Form 10 and Magistrates Court's Form 2 set out what a combined summons should look like and the details it should contain. Number 2.1.4 D. High Court Rule 17, Subsection 3 and Magistrates Court's Rule 5, Subsection 3. Signatures. The summons must be signed by the plaintiff's attorney or the plaintiff if he is representing himself. An address for the service of further documents on the plaintiff in the matter must be set out in the summons. This address is usually that of the plaintiff's attorney and may not be less than 15 kilometers from the office of the registrar. In practice, if the offices of the plaintiff's attorney are situated more than 15 kilometers from the court of which the plaintiff is issuing a summons, the plaintiff's attorney invariably will appoint a correspondent. This is an attorney who does practice within 15 kilometers of the relevant court and who will draft and issue the summons in accordance with the particulars of claim sent by the plaintiff's attorney. The correspondent will then act as a postbox, receiving and dispatching documents on behalf of the plaintiff's attorney. High Court Rule 17, Subsection 3 and Magistrates Court's Rule 5, Subsection 3 must be read in conjunction with High Court Rule 18, Subsection 1 and Magistrates Court's Rule 5, Subsection 1, which stipulates an additional signature requirement for all pleadings other than a simple summons. For all such pleadings in the context of the High Court, the signature of an advocate is required in addition to that of an attorney, unless that attorney is one who has the right of appearance in the High Court in terms of Section 4, Subsection 2 of the Right of Appearance in Courts Act. This Act provides inter alia that an attorney who holds an LLB degree and has been practicing for such at least 3 years may apply to the registrar of the relevant division of the High Court to issue him with a certificate allowing him to appear in the High Court. Number 2.1.4 E. High Court Rules 17, Subsection 4a and b and Magistrates Court's Rules 5, Subsection 4a and b. Citations. The rules appear to require the plaintiff to be cited with slightly more detailed information to which is required for the defendant. The summons must set out the following details for the plaintiff. First, full name. Secondly, gender, if the plaintiff is a natural person. Third, occupation. Fourth, residential address or place of business. And lastly, if the plaintiff is suing in a representative capacity, that capacity must be stated. The summons sets out the following details of the defendant. First, surname and first names or initials by which the defendant is known to the plaintiff. Secondly, residential address or place of business. Third, occupation and employment address, if known. And fourth, if the person being cited is acting in a representative capacity, that capacity must be stated. For example, in inverted commas, in his representative capacity as father and natural guardian of Joe Bloggs. Rule 6, subsection 5D of the Magistrates' Chords rules provides as follows. Where the plaintiff sues in a representative capacity, state the capacity in which he sues. This provision provides for the situation in which either the plaintiff sues or the defendant is sued in a representative capacity. Representative capacity in this context means the relevant party is suing or being sued as the holder of some position, function or office rather than in his personal capacity. The function or office may be any of several different capacities, including, for instance, guardian, executor of an estate, or government minister. In each case, however, it is important to aver the relevant capacity by alleging that the plaintiff is either suing or the defendant is being sued in his capacity as, or words to this effect. Merely stating that the relevant party holds an office without specifically averring that he is suing or being sued in the capacity of that office is insufficient and will merely be held to be descriptive. Remember that when a party is acting in a representative capacity, his name in the header should also indicate that he is acting in a representative capacity. To do so, add the words NO, which stands for nominee officio, after the party's name. Number 2.1.5. Drafting particulars of claim. High Court Rule 18 and Magistrates Court Rule 6. Rule 18 of the High Court Rule and Rule 6 of the Magistrates Court's rules are almost identical and use the same wording for the most part. The differences are relatively minor and will be dealt with in detail under 2.1.6 below. These rules are of fundamental importance as they contain various general provisions relating to the manner in which all pleadings should be prepared and presented. Therefore, the provisions of these rules must be followed carefully when drafting the first pleading. The particulars of claim. Subsections 1 to 3 of Rules 18 and 6 deal with the structure of all pleadings, indicating what they should look like. Subsection 4 of both rules deals with the substance of what all pleadings should contain, and is possibly the most important provision of Rules 18 and 6. Subsections 5 in each set of rules provides for completeness of reply, largely in relation to pleas. Subsection 6 to 11 of Rule 18 and Subsection 6 to 12 of Rule 6 set out the precise averments that should be made in relation to certain specific causes of action. Finally, High Court Rule 18, Subsection 12 and Magistrates Court Rule 6, Subsection 13 provide for the consequences and procedures to be followed in the event of a failure to conform to the provisions of Rules 18 and 6, respectively. Number 2.1.5a. Signatures. High Court Rule 18, Subsection 1 and Magistrates Courts Rule 6, Subsection 1. Apart from those cases in which a party is acting for himself, in which case he will sign himself, the particulars of claim portion of a combined summons must be signed by an advocate as well as an attorney in the High Court. If an attorney has the right of appearance in the High Court, then the attorney may draft the particulars of claim and sign them both without involving an advocate. The summons portion, of a combined summons may be prepared and signed by the attorney alone, as may a simple summons. Magistrates Courts Rule 6, Subsection 1 makes no provision for advocates to sign, referring only to attorneys and unrepresented plaintiffs signing in their own capacity. Although a private person who is representing himself in a High Court matter is entitled to sign a pleading, a juristic person, such as a company or close corporation, is not entitled to do so through one of its officers. This is not the case in the magistrates' courts, as local authorities, companies, or other incorporated bodies, as well as partnerships, may be represented by an officer or, in the latter case, a member nominated for that purpose. Number 2.1.5b. Title of the action. High Court Rule 18, Subsection 2 and Magistrates Courts Rule 6, Subsection 2. In an action, every pleading should have a heading which looks something like this, which you can study on your own time. This is known as the title of the action, and as you can see, it provides sufficient information to enable the registrar to locate the relevant court file. Since every pleading in the action receives the same heading, should the document ever be lost, it is easy for the registrar or any of the parties to trace precisely the action to which the pleadings belongs. In an action which is commenced by a summons, the parties are known as the plaintiff and the defendant, whereas in an application which is commenced by a notice of motion, the parties are known as the applicant and the respondent. The title is followed by two tram lines which run across the page under the title. A description of the pleadings in question is inserted between the tram lines. For example, the particulars of claim within two solid lines, basically. Number 2.1.5c. Paragraphs. High Court Rule 18, Subsection 3 and Magistrates Courts Rule 6, Subsection 4. High Court Rule 18, Subsection 3 and Magistrates Courts Rule 6, Subsection 3 both read as follows. Every pleading shall be divided into paragraphs, including subparagraphs, which shall be consecutively numbered and shall, as nearly as possible, each contain a distinct averment. This rule is helpful in two ways. Firstly, it prevents a pleader from mixing up different points in a confusing jumble of information. Secondly, since each material fact averred is separate and numbered, it is easy for the opposing party to identify and respond to each averment. Number 2.1.5d. The full facts. High Court Rule 18, Subsection 4 and Magistrates Courts Rule 6, Subsection 3. High Court Rule 18, Subsection 4 and Magistrates Courts Rule 6, Subsection 4 are probably the most important provisions within Rules 18 and 6, as they set out a fundamental principle that must be followed when drafting particulars of claim, or any other pleading. High Court Rule 18, Subsection 4 and Magistrates Courts Rule 6, Subsection 4 both provide that every pleading shall contain a clear and concise statement of the material facts upon which the pleader relies for his claim, defense, or answer to any pleadings as the case may be, with sufficient particularity to enable the opposite party to reply thereto. The only material facts you may raise at trial and on which you may rely are those which have been raised in the pleadings. As pointed out previously, the material facts upon which a pleader relies are known as the Facta Prubantia. The material facts will be those facts sufficient to show or disclose a cause of action. These material facts upon which the pleader relies must be distinguished from the evidence that the pleader will adduce in order to prove the material facts. The evidential facts adduced to prove the material facts are known as the Facta Prubantia. When drafting a pleading, you are required, in terms of these rules, to plead the Facta Prubantia, but not the Facta Prubantia. In other words, you are required to plead the facts, but not the evidence in support of those facts. The words "with sufficient particularity to enable the opposite party to reply thereto" adds a further dimension. It means that the party drafting the pleading, the pleader, must not only supply sufficient facts to set out a cause of action or defense, as the case may be, but must also set out the facts in a sufficiently detailed manner to enable the other side to respond. This does not mean that the evidence, the Facta Prubantia, must be provided. It means merely that the Facta Prubantia should go beyond, telling the other side in very general terms that what kind of case they have to meet, and also provide specific averments to which they may specifically reply. The reason that it is so important to set out all the material facts in your pleadings is that it is no longer possible to request further particulars for the purposes of pleadings. In other words, if you leave out some of the material facts, your opponent is placed in an invidious position. He is unable to ask for further particulars, and he cannot respond to your pleadings because he does not know all the material facts. As a result of the virtual abolition of the further particulars at the pleading stage, you have to get your pleadings right first time. Your opponent cannot ask you to provide the omitted facts by requesting further particulars. If you fail to furnish the material facts, the following courses of action are open to your opponent. First, may make an application to have your pleadings set aside as an irregular step in terms of High Court Rule 30. Read with Rule 18, Subsection 12, read with Rule 18, Subsection 4, or the corresponding Magistrates Court's Rule 60A, read with Rule 6, Subsection 13, read with Rule 6, Subsection 4. Or, secondly, accept to your pleadings in terms of High Court Rule 23 or Magistrates Court's Rule 19. Note, however, that mere failure to give sufficient particularity in order to enable the other party to plead will not, in general, entitle that party to accept. The lack of particularity must be so serious as to amount to a failure to disclose a cause of action, or alternatively to render the pleading vague and embarrassing, before an exception may be brought. Number 2.1.5 E. Requirements. Breach of contract. High Court Rule 18, Subsection 6 and Magistrates Court's Rule 6, Subsection 6. High Court Rule 18, Subsection 6 and Magistrates Court's Rule 6, Subsection 6 are almost identically worded and deal with pleadings relating to contracts. In terms of these rules, when you plead in relation to a contract, you must, first, state whether the contract is written or oral. Secondly, state when, where, and by whom it was concluded. And lastly, attach a true copy of the contract to the pleadings in question, unless, of course, it is an oral agreement. Number 2.1.5 F. Requirements. Divorce. High Court Rule 18, Subsection 8 and 9, and Magistrates Court's Rule 6, Subsection 8. High Court Rule 18, Subsection 8 states as follows. A party suing or bringing a claim in reconvention for divorce shall, where time, date, and place, or any other person or persons are relevant or involved, give details thereof in the relevant pleading. For example, if you are alleging that a marriage has irretrievably broken down due to a series of adulterous affairs conducted by the other marriage partner, details of the times, places, and parties involved in the alleged affairs would have to be given. Similarly, incidences of assaults might be pleaded. It might be unwieldy to list every single incident or place, however, particularly if the adulterous relationship occurred over a long period, in which event a somewhat more general reference might be made to divers, sundry incidences of adultery. okay, over a certain period of time, which in most cases would fulfill the requirements of Rule 18, Subsection 4. Since August 2010, the regional divisions of the Magistrates' Courts have jurisdiction to hear divorce matters. Somewhat oddly, however, Rule 18, Subsection 8 has no counterpart in the Magistrates' Courts rules. Since any particularity which might be relevant to divorce proceedings would be included under Rule 18, Subsection 4, this subsection may well have been considered to be superfluous. Hence the possible reason for its non-inclusion in the Magistrates' Courts rules. High Court Rule 18, Subsection 9 and Magistrates' Courts Rule 6, Subsection 8 both read as follows. A party claiming division, transfer or forfeiture of assets in divorce proceedings in respect of a marriage out of community of property shall give details of the grounds on which he claims that he is entitled to such division, transfer or forfeiture. Division involves dividing property between the spouses. Transfer refers to the passing of ownership of property from one spouse to another, and forfeiture means the loss of property or any share in property that one spouse might have gained as a result of the marriage. Let us take the example of a claim for the forfeiture of assets. In terms of Section 2 of the Matrimonial Property Act, if a marriage is set out of community of property, then it is subject to the accrual system, unless the accrual is expressly excluded. The result is that most out of community marriages these days are subject to the accrual system. Section 9 of the Matrimonial Property Act provides that in regard to these marriages, the right to share in the accrual of a spouse may, on divorce, be declared forfeit, either wholly or in part. For example, assume that a millionaire widow marries a penniless gigolo. They enter into an antenuptial contract subject to accrual, and stupidly, the initial values of their respective estates are set at 0. After 1 week of marriage, the gigolo sues the widow for divorce and claims half the accrual, in effect half the widow's estate. In this case, the widow would ask the court to order that the gigolo forfeit his right to accrual sharing. High Court Rule 18, Subsection 9 and Magistrates' Court Rule 6, Subsection 8 require that the widow give details of the grounds on which she claims that she is entitled to the forfeiture. She would have to show that if the gigolo were allowed to share in the accrual, he would be gaining an undue benefit. It seems strange that there is no mention in this subsection of marriages in community of property with regard to the forfeiture issue. The rich widow would be in exactly the same danger in this situation, with even less protection than that afforded by an antenuptial agreement. We are unable to explain why no mention has been made in the rule of marriages in community. We would submit, however, that a plaintiff suing for forfeiture in a community of property situation needs to make exactly the same kind of averments, based on subsection 4 of Rules 18 or 6, which require the pleader to include sufficient detail to enable the other side to respond. Number 2.1.5g. Requirements. Bodily injuries. High Court Rule 18, Subsection 10 and Magistrates' Court Rule 6, Subsection 9. High Court Rule 18, Subsection 10 and Magistrates' Courts Rule 6, Subsection 9 are identically worded and deal with claims for damages. In general, the rules require that if a plaintiff sues for damages, he must set his damages out in such a way that the defendant is reasonably able to assess the quantum, in other words, the amount of the damages. With regards to damages for personal injury, the plaintiff must specify the following. First, his date of birth. A young person may, for example, have a bigger claim than an older person, as he is likely to live longer. Secondly, the nature and extent of his injuries. This is needed for the parties and the court to make an assessment of a claim for pain and suffering, as well as supporting other claims for medical expenses. And lastly, the nature, effects, and duration of the disability. Disability refers to the effect of the injuries on the plaintiff's life. This information is needed for the parties and the court to make an assessment of a claim for loss of the amenities of life, as well as supporting claims for loss of earnings. Personal injuries should be separated into 4 heads of damages, and the plaintiff must state separately what is claimed under each heading. First, medical costs and hospital and other similar expenses, specifying how these costs and expenses are made up. These costs are proved at the trial by providing copies of the medical accounts. Secondly, pain and suffering, specifying whether permanent or temporary and what injury caused this. The amount is proved at the trial by reference to previous court cases in order to establish what the courts have been prepared to grant for similar injuries in the past. An adjustment is then made for inflation in order to arrive at an approximate figure for this part of the claim. Eventually, the court will have to make a final decision on the particular facts before it. And third, disability, which is divided into 2 categories. First, loss of income, which must in turn be divided to income lost to date and estimated future loss of income. With regard to future income, the plaintiff must give details of the work he expects to be able to perform in the future. Income lost to date is proved at trial by providing documents such as previous salary slips, profit statements, etc. Future loss of income is proved at the trial with the help of an actuary, who is able to calculate mathematically the earning capacity of people over the expected course of their lives. Secondly, loss of enjoyment of the amenities of life. For example, a particular plaintiff may have enjoyed playing the piano, but because of an injury to his hand, he can no longer do so. The plaintiff must stipulate whether his enjoyment has been temporarily or permanently terminated. The amount is proved at the trial and in the same way as pain and suffering. And lastly, disfigurement, including a full description of the disfigurement suffered, stating whether it is temporary or permanent. The amount is proved at the trial in the same way as pain and suffering. Note that medical expenses and loss of income are sometimes called special damages, whereas the other categories, which include, for instance, pain and suffering and loss of amenities of life, are called general damages. In the former case, the damages are proved by using hard documentary evidence, including medical accounts and pay records. In the latter case, the damages are more difficult to determine precisely and require the court to reach a decision it feels is just, based on similar cases which have previously come before the courts. Note that the common law pertaining to the quantum of damages only applies to RAF claims, that is, claims under the Road Accident Fund Act in limited circumstances. The Road Accident Fund Amendment Act, which came into effect on the 1st of August 2008, introduced far-reaching changes, a full discussion of which is beyond the scope of this book. These changes are highly controversial and too numerous to enumerate in detail here. The general effect, however, is to deprive the innocent parties in motor vehicle collisions of the general damages to which they were entitled at common law, unless the party suffered a serious injury in terms of Subsection 17(1) and 1A of the Road Accident Fund Act. Paradoxically, the limitation of 25,000 rand that previously applied to the claims of the passengers in the motor vehicle of which the driver was solely at fault have been removed. In addition, a limit prescribed in regulations has been placed on claims for loss of income, while compensation for medical treatment is restricted to a tariff in terms of Section 17, Subsection 4B of the Act. Number 2.1.5H. Requirements. Death. High Court Rule 18, Subsection 11, and Magistrates Courts Rule 6, Subsection 10. In terms of the identically worded High Court Rule 18, subsection 11, and Magistrates Courts Rule 6, subsection 10, a plaintiff suing for damages resulting from the death of another shall state the date of birth of the deceased as well as that of any person claiming damages as a result of the death. A claim for loss of support may be brought by any of the deceased's lawful dependents. The various dates of birth are required to enable the parties to obtain actuarial assessments as to the dates on which, but for his death, the provider would have ceased providing support. Claims for loss of support have also been affected by the Road Accident Fund Act 56 of 1996, and claims from the Road Accident Fund are limited to an amount prescribed in regulations to the Act, in respect of each deceased breadwinner. Number 2.1.5i. Implications of not following High Court Rule 18, subsection 12 and Magistrates Courts Rule 6, subsection 13. High Courts Rule 18, subsection 12 and Magistrates Courts Rule 6, subsection 13 are almost identically worded and provide as follows. If a party fails to comply with any of the provisions of this rule, such pleadings shall be deemed to be an irregular step and the opposite party shall be entitled to act in accordance with Rule 30 in the case of a High Court matter and Rule 60A in the case of the Magistrates Courts. Failure to comply with the requirements of Rules 18 or 6 when drafting pleadings will mean that the pleadings will be deemed to be an irregular step and the opposing party will be entitled to bring an application to have the pleading set aside in terms of Rule 30 in the case of a High Court matter and almost identically worded Rule 60A in the case of a Magistrates Courts. Furthermore, failure to follow Rules 18 or 6 to the letter may in certain circumstances also render the pleading excipiable. That is, the opposing party may have sufficient grounds on which to note an exception against the pleading in terms of High Court Rule 23 or Magistrates Courts Rule 19. In either case, failure on the part of the pleader to rectify the pleading may eventually lead to the claim or defense being dismissed or set aside. High Court Rules 23 and 30 and the Magistrates Courts Rules 19 and 60A are dealt with in detail later. You should note, however, that of the two potential remedies, an application under High Court Rule 30 and Magistrates Courts Rule 60A are the most important, at least in the context of failure to conform to Rules 18 or 6. This is because there may be instances where a pleading may not be excipiable, but may still amount to an irregular step since it does not conform to Rules 18 or 6. For example, particulars of claim may disclose a cause of action and be sufficiently clear so as not to be vague and embarrassing, and therefore not be excipiable, but still fail to provide the particularity required by Rule 18, subsection 4 or 6, subsection 4, and therefore fall foul of Rule 18, subsection 2 or Rule 6, subsection 13. In this case, only the remedy provided by Rules 30 or 60A would apply. Number 2.1.5J. Further averments relating to the Magistrates' Courts only. Note that Rules 6, subsection 11 and 12, which relate to causes of action arising out of or regulated by legislation and session, respectively, are not common to both sets of rules and are dealt with in section 2.1.6 below. 2.1.6 Provisions for summonses relating exclusively to the Magistrates' Courts. By and large, the High Court and Magistrates' Courts rules as they relate to summonses have been standardized. Some differences remain, however. Several provisions requiring additional specific averments to be made in particular situations appear in Magistrates' Courts Rule 5, such as Rules 6, subsection 11 and 12, which relate to causes of action based on legislation and sessions respectively. 2.1.6a Electronic addresses. The Magistrates' Court's rules make provision for the use of electronic addresses. In terms of Rule 5, Subsection 3a(1), the plaintiff's attorney must, where available, include his electronic and facsimile address as well as postal address in the summons. Furthermore, in terms of Rule 5, Subsection 3b, the plaintiff may indicate in the summons whether he is prepared to accept service of all subsequent documents and notices in the suit through any manner other than the physical address or postal address, and if so, which manner of service would be preferred. There is also provision in Rule 5, Subsection 3c, for the defendant in response to the written request of the plaintiff to deliver a consent in writing to the exchange or service by both parties of subsequent documents and notices in the suit by way of facsimile or electronic mail. Should the defendant refuse or fail to deliver the consent, the court may, on application by the plaintiff, grant such consent, on such terms as to costs and otherwise as may be just and appropriate in the circumstances. This would appear to be an attempt to encourage the use of electronic means for the exchange of documents, but must be balanced against the need for certainty as to service of the documents and fairness to both parties. Before any documents or pleadings are delivered by way of facsimile or electronic mail, a written agreement should be lodged with the registrar in which the parties agree to delivery in this manner. The agreement must also contain the facsimile number or electronic mail address where delivery must be effected. Number 2.1.6b Provisions for the defendant. Magistrates' Court's Rule 5, Subsection 5 stipulates that the summons must include the following information for the benefit of the defendant. First, a form of consent to judgment. Secondly, a form of appearance to defend. Third, a notice drawing the defendant's attention to the provisions of Section 109 of the Magistrates' Courts Act, which requires a judgment debtor to keep the court, creditor or creditor's attorney, and if applicable, an administrator informed of any change of address. And fourth, a notice in which the defendant's attention is directed to the provisions of various sections of the Magistrates' Courts Act relating to debt collection, including subsection 57, 58, 65a and 65d, where the action is based on a liquidated sum of money due in terms of section 55 of the Act. Provisions is made for all these requirements in Forms 2, Simple Summons, and Form 3, Summons incorporating an automatic rent interdict, which provide models for the structure and content of the summonses. Number 2.1.6c Provision for jurisdictional averments. Magistrates' Courts Rule 5, Subsection 6 require certain allegations to be made with regard to jurisdiction. Rule 5, Subsection 6a provides that where the defendant is cited under the jurisdiction conferred upon the courts by Section 28, Subsection 1d of the Magistrates' Courts Act, which relates to jurisdiction based on the cause of action, the summons must contain the averment that the whole cause of action arose within the district or region, in the case of a regional magistrates' court. The rule specifically requires that the summons set out particulars in support of this averment. This means that the usual statement to the effect that the cause of action arose wholly within the jurisdiction of the above honourable court would not be valid for the purpose of a magistrate's court summons. The requirement applies to all summonses, including simple summonses, which is an anomaly given that a simple summons is not required to comply with the particularity stipulated in Rule 6, Subsection 4. Rule 5, Subsection 6b provides that when a plaintiff relies on Section 28, Subsection 1g of the Magistrates' Courts Act for jurisdiction, that is, in an action relating to immovable property where the plaintiff avers that the immovable property concerned is situated within the district of the Magistrates' Court in question, the particulars should include the averment that the property concerned is situated within the district or region. Finally, Rule 5, Subsection 6c provides that the summons should show any abandonment of parts of the claim under Section 38 of the Magistrates Courts Act and any set off under Section 39 of the Magistrates Court Act. Number 2.1.6 D. Provisions relating to legislation. Rule 5 makes provision for claims regulated by legislation. This may include the various acts dealing with the suing of government departments, which require particular procedures such as giving notice before service of summons, or claims based on credit agreements regulated by the National Credit Act. Rule 5, Subsection 7 provides a general direction to the effect that where the plaintiff issues a simple summons in respect of a claim regulated by legislation, the summons may merely contain a bare allegation of compliance with the legislation. If an appearance to defend is served by the defendant on receipt of the simple summons, however, and the plaintiff responds with a declaration, the declaration must allege full particulars of such compliance. The situation is somewhat different where the original cause of action is a credit agreement under the National Credit Act, by which the plaintiff seeks to obtain judgment in terms of Section 58 of this Act. In this instance, the summons must deal with each one of the relevant provisions of subsection 129 and 130 of the National Credit Act and allege that each one has been complied with, even in the case of a simple summons. It must specifically contain sufficient allegations as to the manner in which the Section 129, subsection 1a notice was delivered so as to place the court in a position to determine whether there was delivery in terms of the National Credit Act. Furthermore, most of the practice directives of the various divisions have specific requirements as to what must be alleged in the summons. A similar provision features in Rule 6, Subsection 11, in terms of which a party who relies on a cause of action arising out of or regulated by legislation shall state the nature and extent of the party's compliance with the relevant provisions of such legislation. This would include agreements concluded in terms of the National Credit Act, of course. Number 2.1.6 E. Suing as a cessionary. Rule 5, Subsection 9 provides that where the plaintiff sues as cessionary, the plaintiff must indicate the name, address, and description of the cedent of the date of cession, as well as the date of the cession. Without an averment making it clear that the action has been ceded, the particulars of claim would fail to show the plaintiff's interest in the matter. His locus standi. The necessary averment would read more or less as follows. The plaintiff sues as cessionary in terms of an agreement of cession dated, in terms of which the cedent, including name, address, and description of cedent, ceded his right, title, and interest in the action to the plaintiff. Rule 6, Subsection 12 contains a similar provision to the same effect, a requirement which is not present in the current High Court Rule 18. An averment of this nature would always be necessary to support a cause of action based on a ceded right. However, and would therefore be implicit in terms of Rule 18, Subsection 4, or Rule 6, Subsection 4 of the Magistrates Courts Rules, for that matter. Number 2.1.6 F. Declaration that immovable property is executable. In terms of Rule 5, Subsection 10, a summons in which an order is sought to declare immovable property, which is the home of the defendant, executable, must also contain a notice in the following form. The defendant's attention is drawn to Section 26, Subsection 1 of the Constitution of the Republic of South Africa, which accords to everyone the right to have access to adequate housing. Should the defendant claim that the order for eviction will infringe that right, it is incumbent on the defendant to place information supporting that claim before the court. Number 2.1.6g. Automatic rent interdict summons. Rule 5, subsection 8 makes provision for a summons in respect of a rent claim which includes an automatic rent interdict. In terms of Section 31 of the Magistrates Courts Act, when issuing a P12 summons for arrear rent in the magistrates' courts, it is possible to include what is called an automatic rent interdict in the summons. In other words, the landlord will include in his summons a notice prohibiting any person, including obviously the tenant, from removing from the premises any furniture or other effects which are subject to the landlord's hypothec. For rent, that is, which belongs to the persons who owe or owes the rent, until the court makes an order as to what is to become such furniture and other effects. Anyone who has knowledge of this notice is interdicted, that is, legally prohibited from removing the said furniture or other effects, until the court reaches its decision. In order to ensure that the tenant does not remove items without the landlord's knowledge, the landlord may, at his own expense, request the sheriff to make an inventory of the goods, which will enable the landlord to check whether or not items have been removed from the premises after the inventory is made. If items have been removed, the person who removes them faces conviction in terms of Section 106 of the Magistrates Courts Act, which reads as follows. Any person wilfully disobeying or refusing or failing to comply with a notice lawfully endorsed on a summons for rent prohibiting the removal of furniture or effects shall be guilty of contempt of court and shall, upon conviction, be liable to a fine or to imprisonment for a period not exceeding 6 months, or to such imprisonment without the option of a fine. This provides a remedy in theory, but is of title consolation to the landlord who wants payment of the money due in respect of the rent. A procedure is available, however, for a landlord who is not interested in having the tenant committed to prison, but would rather secure the tenant's goods as soon as possible. In this case, he would use the procedure set out in Section 32 of the Magistrates Courts Act. In terms of Section 32, a landlord who is owed rent may make an application to court for an order allowing for the attachment of movable property on the rented premises. Only such goods as are A. subject to the landlord's hypothec for rent, and B. sufficient to satisfy the amount of rent which is outstanding may be attached. The application must be supported by an affidavit in which the landlord alleges inter alia that, first, he has demanded the arrear rent in writing and more than 7 days have passed without the arrear rent being paid, or secondly, he believes that the tenant is about to remove the movable property which is on the rented premises in order to avoid payment of the rent. In addition, the landlord must give security to the satisfaction of the clerk of the court that he will pay all damages, costs, and charges which the tenant or any other person may sustain or incur by reason of the attachment. If the court grants the application, the landlord may, with the approval of the clerk of the court, in terms of the Magistrates Courts Rule 41, Subsection 7a, instruct the sheriff to attach and immediately remove that property to a place of security. In this way, the landlord is able to secure the tenant's property before it is spirited away. Bear in mind that in magistrates' courts practice, the sheriff will usually attach goods without removing them. The sheriff will merely make an inventory and inform the tenant that the goods are attached. This means that it is necessary to give the sheriff a further instruction should the landlord want the property to be removed. In such cases, the plaintiff will have to pay the costs of removal and storage. This presents the landlord with a dilemma, since although the costs of removal and storage may theoretically be recovered when the goods are auctioned, the amounts realized at sales in auction are often low. It is wise to keep costs as low as possible if it seems likely that the tenant's goods will be worth very little. Rule 5, subsection 8 provides that the summons must be in the form prescribed in Annexure 1, Form 3. Finally, the defendant has to be warned to enter an appearance to defend within 10 days after the service of the summons, and the consequences of not doing so, namely that default judgment may be taken against him. Number 2.1.7 Lapsing and Superannuation of Summons and Judgments. Number 1. Superannuation of Summons. Rule 10 of the Magistrates' Court's rules previously provided for the lapsing of a summons in two situations. The summons would lapse if it had been issued but not served within a period of 12 months. Alternatively, the summons would lapse if no further action to prosecute the matter was taken by the plaintiff within 12 months after service. This rule was amended in its entirety and no longer contains a provision to this effect. As regards High Court practice, however, there is some judicial authority that a High Court summons can go stale, inasmuch as an unreasonable delay in proceeding with an action may be regarded as an abuse of process. Number 2. Superannuation of Judgements. As regards superannuation of judgments, the first point to be aware of is that, in terms of the Prescription Act, a judgment debt does not prescribe until a period of 30 years has lapsed. Nevertheless, the process of execution against a judgment debtor's property pursuant to the judgment will not be permitted if not acted upon promptly. Section 63 of the Magistrates' Courts Act provides execution against property may not be issued upon a judgment after 3 years from the day on which it is pronounced, or on which the last payment in respect thereof was made, except upon an order of the court. A magistrate's court's judgment sounding in money thus superannuates within 3 years of the judgment being granted. Alternatively, and in the event that the debtor began to make payment towards the judgment debt, but ceased to do so before payment was made in full, the 3-year period is calculated from the date of receipt of the last payment. This being the case, execution of a judgment must take place within the 3-year period, after which time it will have superannuated. If superannuation does occur, an application must be made to revive the superannuated judgment. In the High Court, Rule 66, Subsection 1 previously provided that no writ of execution could be issued after 3 years. This rule, however, was eliminated in 2014. Rule 66 now provides that a writ of execution for the enforcement of a judgment, once issued, remains in force until the judgment debt prescribes in terms of the Prescription Act. Furthermore, in terms of this rule, the writ of execution may be executed at any time without being renewed. The recent amendments create something of an anomaly in that in the Magistrates' Court's process can only go stale after judgment, as per Section 63, whereas High Court process can only go stale prior to judgment, based on common law. Another possibility is that with the amendment of Rule 10, the common law position applies to the magistrates' courts as well. Number 2.2. Step 2. Notice of intention to defend. Once the summons has been served on the defendant, he has several choices. First, he may decide to do nothing, which will usually result in the plaintiff obtaining a default judgment against him. Secondly, he may contact the plaintiff's attorney and attempt to settle the matter by agreement. Thirdly, in the magistrates' courts, he may consent to judgment, with similar results to default judgments, albeit with a slight saving in costs. A similar procedure, called confession to judgment, exists in the High Court. And lastly, he may decide to defend the matter, in which case he must enter an appearance to defend, and the matter will proceed on a defended basis. Let us assume that he decides to enter an appearance to defend the matter. Number 2.2.1. The notice. The notice of intention to defend is provided for in Rule 19 of the High Court Rule and Rule 13 of the Magistrates Court's rules. The rules are virtually the same. An appearance to defend is usually entered by the defendant's attorney, who deliver a notice both to the court and the plaintiff called a notice of intention to defend. This notice simply tells the plaintiff and the court that the defendant intends to defend the action, and appoints an address for service on the defendant of further documents in the action. The notice has the effect of placing the defendant's attorney on record. In terms of High Court Rule 16, Subsection 4, should the defendant's attorneys in a High Court matter wish to cease representing the defendant after placing themselves on record and before the matter has been concluded, they are required to withdraw formally by sending a notice to the defendant, the plaintiff's attorneys, and the court. This must be done timeously. The same procedure must be followed in magistrates' courts matters. The service address is the address at which the defendant wishes to receive service of all future documentation in a matter, but that is not the only address which should feature in the notice. The Magistrates' Court's rules are not identical to the High Court rules in this regard. Nevertheless, Magistrates' Court's Rule 13, Subsection 3 and High Court Rule 19, Subsection 3 both require the defendant to provide his or her full physical, residential, or business address in the notice. Note that these addresses have not always been provided in practice. The Magistrates' Court's rule goes further, however, requiring also the defendant's postal address and, where available, a facsimile address and electronic mail address. Having provided all these addresses in the notice, the defendant should then select an address for the service of all subsequent documents in the matter. Unless the defendant is unrepresented, this address would be that of his attorney rather than one of the defendant's addresses listed immediately above. Rule 4A of the High Court Rules, inserted in June 2012, now provides that the service of all documents, apart from those initiating proceedings, may be effected either at the physical address for service provided in the notice, by registered post to the postal address provided, or via facsimile or electronic mail to the respective addresses provided. The rule, however, does not appear to require such additional addresses to be given in the notice. In both the High Court and Magistrates' Court's rules, this service address needs to be within 15 kilometers of the court out of which the summons was issued. In High Court practice, the address must be a street address and may not be a post office box address. In contrast, the Magistrates' Court's rules do not impose any restriction on the type of address that may be used, and the implication is that the use of postal address, including post office boxes, would still be valid. The Magistrates' Court's rules also make provision for the use of electronic addresses. Furthermore, Rule 13, Subsection 3b requires the defendant to indicate in the notice of intention to defend whether the defendant is prepared to accept service of all subsequent documents and notices in the suit through any manner other than the physical address or postal address, and if so, to state such preferred manner of service. Rule 13, subsection 3c provides that the plaintiff may, at the written request of the defendant, deliver a consent in writing to the exchange or service by both parties of subsequent documents and notices in the suit by way of facsimile or electronic mail. Finally, in terms of Rule 13, subsection 3d, if the plaintiff refuses or fails to deliver the consent in writing as provided for in Rule 13, subsection 3c, the court may, on application by the defendant, grant such consent, on such terms as to costs and otherwise as may be just and appropriate in the circumstances. It would seem, however, that the initial address for service must be either physical or postal, and that the plaintiff will serve his response to a request for service by way of electronic means to the physical or postal address supplied by the defendant. This provision reflects a similar stipulation pertaining to the plaintiff's plaintiff and summonses in Rule 5, Subsection 3, and would appear to be an attempt to encourage the use of electronic means for the exchange of documents. The High Court rule also provides that if the plaintiff refuses or fails to deliver the consent in writing, the court may, on application, grant such consent. Furthermore, in the Regional Magistrates Court, before any documents or pleadings is delivered by way of facsimile or electronic mail, a written agreement must be lodged with the registrar in which the parties agree to deliver in that manner. Once an address has been selected, however, service at this address will be valid and effectual except where by any order or practice of the court personal service is required, which means that any documents in the matter properly served at that address will be deemed to be received by the defendant and the defendant's legal representatives. Entering an appearance to defend does not prevent a defendant from raising an exception or a special plea at a later stage in the proceedings. For example, at a later stage in the proceedings, the defendant may claim that the plaintiff has sued the wrong person, or that the person's claim has prescribed, or that the court has no jurisdiction. High Court Rule 19, Subsection 4 and Magistrates Courts Rule 13, Subsection 4 both provide that the defendant will not be deemed to have waived any right he may have to object to the jurisdiction of the court or to any irregularity or impropriety in the proceedings. Number 2.2.2 Delivery of the notice. The appearance to defend is entered by delivering one copy of the notice to the registrar or clerk of the court, and one copy to the plaintiff or his attorney. The word deliver is defined in a similar fashion in both the High Court and the Magistrates Court's rules. It involves two activities: serving a copy on the opposing party and filing the original document at the court. A notice of intention to defend need not be served by the sheriff of the court. It is usually delivered by a messenger working for the defendant's attorney. The messenger will deliver the original and two copies of the notice to the offices of the plaintiff's attorney. The receptionist at the office of the plaintiff's attorney will indicate that the plaintiff's attorney have received the notice by stamping the original as well as two copies with the firm's name and the date of service. The receptionist will hand the original and one of the copies back to the messenger, retaining one copy to be placed on the file of the plaintiff's attorneys. Having served the notice, the messenger will then file it at court by handing the original and remaining copy to the clerk or registrar, who will date stamp both documents, retaining the original for the court file and returning the copy to the messenger. Once the original notice has been placed on the court file, any dispute which may arise as to whether or not there has been proper or timely service may be resolved by referring to the date stamps. The messenger will return the remaining copy of the notice to the defendant's attorney for filing. Presumably, the introduction of electronic means of service will not modify this greatly, as the documents will still need to be filed at the court by the parties who served them. Proof of service by electronic mail may require novel methods to prove service, such as email delivery or read receipts, confirmation from an electronic service provider that the document was delivered, or confirmation that an embedded hyperlink in the message envelope was assessed, or verbal confirmation by the recipient. Number 2.2.3 Dis indiciae. In both the High Court and Magistrates Courts, there are time limits, known as the dis indiciae, within which the defendant is required to enter an appearance to defend. If the defendant fails to enter an appearance to defend within the stipulated time limit, the plaintiff may take default judgment against him. In High Court matters, the time within which the defendant is allowed to enter an appearance to defend depends on whether the summons was served upon the defendant inside or outside the jurisdiction of the court which issued the summons. In terms of High Court Rule 19, Subsection 1, if a summons is served inside the jurisdiction of the court which issued it, a defendant is allowed 10 court days after service within which to deliver a notice of intention to defend. It is important to note that the days between the 16th of December and the 15th of January, both days inclusive, are not counted when calculating this period. These days are known as dies non, literally non-days. In terms of Section 24 of the Superior Courts Act, if the summons is served outside the jurisdiction of the court which issued it, the appearance to defend must be delivered not less than, first, 1 month after service if the place of service is more than 150 kilometers from the court from which it was issued, and secondly, 2 weeks in any other case. Virtually, the same provision applies to the magistrates' courts in terms of Rule 13, Subsection 1, including provisions for the dies non, except that there is no distinction made between a summons being served inside or outside the jurisdiction of the court. In all cases, the period allowed the defendant within which to deliver a notice of intention to defend is 10 court days from service of summons. In terms of High Court Rule 19, Subsection 2, if the action is against a minister, deputy minister, premier of a province, officer, or servant of the state in his official capacity, the state itself, or a provincial administration, a period of 20 court days will be allowed for the entry of an appearance to defend. Note that whereas the days referred to in High Court Rules 19, Subsection 1 and 2 are court days as defined in High Court Rule 1, the days referred to in Section 24 of the Superior Courts Act are calendar days, since they are referred to in the Act as opposed to the rules. It is important to employ the correct calculation method when calculating the respective periods. In both the High Court and Magistrates' Courts, it is possible for a notice of intention to defend to be entered after the dies indiciae have expired. This may be done despite the fact that the plaintiff has requested default judgment, provided that default judgment has not yet been granted. In such cases, the plaintiff is entitled to the costs of his application for default judgment. Number 2.3. Step 3. Plea and counterclaim. Number 2.3.1. Plea. Number 2.3.1a. General overview. The plea is essentially the defendant's reply to the plaintiff's particulars of claim and contains the defendant's defense to the plaintiff's claim. There are two main kinds of plea. First, the plea on the merits, and secondly, a special plea. A plea on the merits deals with the substance of the plaintiff's claim. It attacks the validity of the cause of action with regard to the facts of the case. For example, assume a plaintiff is claiming for damages to his motor vehicle caused by a collision with the defendant's vehicle. The plaintiff's plea on the merits may deny that the defendant drove negligently. This plea strikes at the heart of the plaintiff's cause of action, since negligence is one of the elements which the plaintiff will have to prove in order to be successful in an action in terms of the lex equalia. A special plea is essentially a legal objection to some aspect of the plaintiff's claim. It tries to knock out the plaintiff's case before the merits of the plaintiff's case are even considered. In the above example, the defendant may raise a special plea that the plaintiff's claim has prescribed. In other words, even if the defendant were to be blamed for the collision, it does not matter. The plaintiff has no claim in law because the matter has prescribed. In practice, even if a special plea is raised, it is usual to plead over on the merits. In other words, a plea on the merits is added as an alternative to the special plea in case the special plea does not succeed for one reason or another. Pleas are dealt with in Rule 22 of the High Court Rules and Rule 17 of the Magistrates' Courts Rules. Apart from a slight change in wording and additional provisions dealing with tenders, Rule 17 of the Magistrates' Courts Rules matches Rule 22 of the High Court Rules. Number 2.3.1b. Plea on the merits. Rule 22 of the High Court Rules and Rule 17 of the Magistrates' Courts Rules set out the requirements with which the defendant's plea must comply. The provisions of Rules 22 and 17 must be read with the general provisions relating to pleading contained in Rule 18 of the High Court Rules and Rule 6 of the Magistrates' Courts Rules, respectively. Number 2.3.1b1. Time limits. In terms of Rule 22, Subsection 1 of the High Court Rules and Rule 17, Subsection 1 of the Magistrates' Courts Rules, the defendant must, within 20 court days after delivering his notice of intention to defend, in the case of a combined summons, or receiving the plaintiff's declaration in the case of a simple summons, deliver his plea to the plaintiff. The 20 court day time limit does not apply if the defendant decides to accept to the plaintiff's particulars of claim or declaration, or to make an application to strike out allegations contained therein. The exception or application to strike out will be dealt with first, before the defendant is required to plead. Number 2.3.1b2. The different kinds of pleas on the merits. High Court Rule 22, Subsection 2 requires that the defendant shall, in his plea, either admit or deny or confess and avoid all the material facts alleged in the combined summons or declaration, or state which of the said facts are not admitted and to what extent, and shall clearly and concisely state all material facts upon which he relies. Rule 17, Subsection 2 of the Magistrates' Courts Rules is almost identically worded. The plaintiff's particulars of claim contains the allegations of fact made by the plaintiff, which can only be allegations at this stage, since they have not yet been tested in court. For this reason, the material facts referred to in Rules 22, Subsection 2 and 17, Subsection 2 are generally called allegations and sometimes averments. Rules 22, Subsection 2 and 17, Subsection 2 must be read with Rule 18, Subsection 5 of the High Court Rules and Rule 6, Subsection 5 of the Magistrates' Courts Rules. Rule 18, Subsection 5 of the High Court Rules reads as follows. When in any pleading a party denies an allegation of fact in the previous pleading of the opposite party, he shall not do so evasively, but shall answer the point of substance. Rule 6, Subsection 5 of the Magistrates' Courts Rules are almost identically worded. When responding to the allegations contained in the plaintiff's particulars of claim, the defendant may respond, that is, plead, to each allegation of fact in one of the following 4 ways. First, the defendant may admit the allegation. Secondly, the defendant may deny the allegation. Third, the defendant may confess and avoid the allegation. Or if he is unable to admit or deny or confess and avoid, usually because he has no knowledge of the particular allegation, then, lastly, the defendant may respond that he does not admit the allegation, and indicate to what extent the allegation is not admitted. What this means is that in relation to each of the material facts, the Facta Prubantia, in the plaintiff's particulars of claim or declaration, that is, in response to each and every fact contained in each and every paragraph, the defendant must either, first, admit such fact, secondly, deny such fact, third, confess such fact, but avoid the legal implication the plaintiff would like the court to draw from the fact, or if and only if he cannot admit or deny or confess and avoid, usually because he has no knowledge of the particular allegation, then, lastly, the defendant must make no admission but put the plaintiff to the proof of the particular fact. In addition to the 4 main categories of responses listed in Rules 22, Subsection 2 and 17, Subsection 2, there are 3 general responses that are worth mentioning. The first is provided for in Rules 22, Subsection 4 and 17, Subsection 4, which deal with the situation that will occur if the defendant has no defense to the plaintiff's claim, but has a counterclaim which will extinguish the claim, either entirely or in part. The second general purpose is not specifically dealt with in the rules but is permitted as a matter of common practice. This is to plead in the alternative, which occurs when there is a second possible defense to the plaintiff's claim which is inconsistent with the first defense raised. The last general response is also not dealt with in the High Court rules, namely a plea of tender. Although the Magistrates Court's Rule 17, Subsection 5 specifically provides for such a plea, it is used in both types of courts, however, and is therefore worth mentioning here as a separate kind of plea. We may therefore add the following three categories of pleas. First, plead a counterclaim. Secondly, plead an alternative defense. Or lastly, plead a tender. Let us deal with each of the different kinds of pleas in more detail. Number 2.3.1 B2a Admission of Facts. One of the main reasons for pleadings is to define the issues that are in dispute between the parties. Once the facts contained in a particular paragraph have been admitted, they become common cause, and the plaintiff need not prove them by leading evidence at the trial. Any fact that may be implied from the facts that have been admitted is also deemed to have been admitted, unless specifically denied. Should the defendant fail to deal with any averment in the plaintiff's particulars of claim, it will be deemed to have been admitted. Note that once an allegation has been admitted, it is extremely difficult for the defendant to retract the admission. Should the defendant wish to do so, he will need to amend his plea. If the plaintiff does not consent to the amendment, the defendant will be obliged to bring a formal application requesting the amendment. The court hearing the application is not likely to permit the amendment unless the defendant can show that there was an error and satisfy the court that the plaintiff will not be prejudiced. The court has a discretion that will require a reasonable explanation both of the circumstances under which the admission was made and the reasons why the defendant wishes to withdraw it. Number 2.3.1 B2b Denial of Facts. Facts which are denied are placed in issue and must be proved at the trial. For example, in a motor vehicle collision case, the averments in the plaintiff's particulars of claims alleging that the defendant was negligent are almost always denied, unless the defendant is able to show that no damages were suffered by the plaintiff's failure to deny negligence would mean that the defendant has failed to disclose a defense. Note, however, that a bare denial is not allowed. What is meant by a bare denial is explained below in our discussion of the plea of confession and avoidance. At this point, note that it is necessary to be clear and definite when denying an allegation. Rule 18, Subsection 5 states as follows. When in any pleading a party denies an allegation of fact in the previous pleading of the opposite party, he shall not do so evasively, but shall answer the point of substance. Rule 6, Subsection 5 of the Magistrates Court's rule is almost identically worded. An evasion is to half deny or half admit an allegation, which renders the plea unclear. The reason that a denial of an allegation of fact should be clear and unequivocal and should not be done in an evasive manner is that it should not leave the plaintiff in doubt about what he needs to prove at trial. Number 2.3.1 B2c Confession and Avoidance. A plea of confession and avoidance is one in which the defendant admits, that is, confesses, a particular averment in the plaintiff's particulars of claim, but then sets out new facts which, if proved, would justify or excuse the defendant's admitted conduct, that is, avoid. For example, assume that a plaintiff alleges that a defendant assaulted him and broke his nose. The defendant confesses that he punched the defendant and broke his nose, but avers that he did so in self-defense, avoids or effectively denies liability. If the new facts raised by the defendant are correct, it means that he is not liable for the plaintiff's claim. Were the defendant simply to admit that he punched the plaintiff and broke his nose without explaining that the punch was in self-defense, his subsequent denial of liability for the plaintiff's damages would amount to a bare denial. In other words, a plea of confession and avoidance is sometimes necessary in order to avoid a subsequent denial of liability being categorized as a bare denial. Note that with a plea of confession and avoidance, the onus shifts to the defendant to prove the new facts raised by him. Usually, the onus rests with the plaintiff to prove his case, but when the defendant confesses to the plaintiff's case, and seeks to rely on additional facts for his defense, it is up to the defendant to prove these additional facts. Number 2.3.1 B2d. Non-admission. The fourth kind of plea is known as a plea of non-admission. It may only be used if, for some good reason, the defendant is unable to put forward one of the other three pleas discussed above in response to a particular allegation of the plaintiff's particulars of claim. Usually, this happens when the defendant simply does not know anything about the particular allegation. An example of the kind of averment that would usually require this category of response is the averment in a motor collision, where the plaintiff is the owner of the vehicle that was damaged. This averment may well be true, but unless the defendant happens to know the plaintiff personally, it is quite impossible for him to be sure whether or not the plaintiff is the owner. The defendant is quite entitled to plea non-admission and put the plaintiff to the proof of this particular averment, which is essential to the plaintiff's case since it serves to establish the plaintiff's locus standi. A plea of non-admission has the same effect as a plea of denial. The only practical difference between the two is that a plea of denial is a little more emphatic than a plea of non-admission. Although the rule does not specifically provide for this, a reason for making a plea of non-admission must be supplied. The reason in the above case would be simply that the defendant has no knowledge, and the pleading would read more or less like this. The defendant has no knowledge of the contents of this paragraph, cannot admit it, and therefore puts the plaintiff to the proof of it. Number 2.3.1 B2e. Counterclaim. When a defendant has a counterclaim against the plaintiff, the defendant may refer to the counterclaim in his plea and request that the court postpone judgment on the plaintiff's claim until the counterclaim has been adjudicated upon. It may happen that the defendant has no defense to the present claim, but a successful counterclaim, if set off against the plaintiff's claim, will extinguish it at least in part, if not entirely. If the counterclaim is for less than the plaintiff's claim and there is no other defense, the court may give judgment against the defendant for the amount by which the claim exceeds the counterclaim. This situation is provided for in Rule 22, Subsection 4 of the High Court Rules and Rule 17, Subsection 4 of the Magistrates Court's Rules, and pleading a counterclaim is still permissible even if the counterclaim is unliquidated. The rule has been held to allow only for the situation where both claim and counterclaim are heard in the same court. The court is given a discretion by the rule, however, and it would be unlikely to permit a postponement in situations where the plaintiff would be unfairly prejudiced, such as a tenant attempting to stave off an ejectment with a totally unrelated counterclaim. Number 2.3.1 B2F. Alternative defense. Occasionally, the defendant has two possible defenses, but is not sure which to use. In such circumstances, he may use both, provided he pleads in the alternative. In a case claiming damages caused by negligent driving, for example, the defendant may deny that he drove his car negligently. In the alternative, the defendant may plead that even if he is found to have been negligent, the plaintiff was also negligent, and therefore a situation of contributory negligence exists. Similarly, in answer to a claim for goods sold and delivered, a defendant may deny that he has entered into a contract with the plaintiff. For example, he may suspect that the plaintiff was only an agent for the seller. He may plead in the alternative that the purchase price was paid. All conflicting pleas such as this must be pleaded in the alternative. Otherwise, they are read together and considered to be vague and embarrassing, and the plaintiff is able to take an exception. Alternative pleas are not provided for in the rule, but are permitted nonetheless, provided they are necessary to meet the real justice of the case. Drafting a plea in the alternative is a reasonably simple exercise. The first version will be pleaded, followed by the word alternatively, and then the alternative version. Remember, however, that you may only plead contradictory versions of events if your client is really not sure which version is correct. If your client knows full well that one of the versions of event is not correct and instructs you to do this effect, you would be acting unethically if you were to assist him to plead the incorrect version as an alternative to another version of the events. This would amount to assisting your client to lie to the court. In other words, contradicting versions may not be pleaded if your client is bona fide in respect of the allegations contained in the alternative versions. In the case of the two examples given above, one could only plead the contradictory versions in the alternative if the defendant was really not sure if he had been negligent or not. The first example, or if he had entered into a contract with the plaintiff or not. The second example. Number 2.3.1 B2G. Tender. This type of plea is discussed in the section on settlement and therefore will not be discussed here. To sum up, the way in which the defendant is required to respond to each and every material fact in the plaintiff's particulars of claim is by giving one of the following answers. First, yes, that is a plea of admission. Secondly, no, a plea of denial. Third, yes, but, plea of confession and avoidance. Or lastly, I've got no way of knowing, you prove it, a plea of non-admission. And in response to the particulars as a whole, first, you've got a claim, but so have I, pleading a counterclaim. Secondly, this is my defense. Alternatively, this is my defense, pleading the alternative. Or lastly, this matter has already been settled, pleading a tender. Number 2.3.1 B3. Drafting a plea on the merits. We noted above that High Court Rule 18, Subsection 3 and Magistrates Courts Rule 6, Subsection 3 require pleadings, including therefore the particulars of claim and the plea, to be divided into consecutively numbered paragraphs. These paragraphs are merely containers for the different allegations. Therefore, each paragraph will also contain one or a number of allegations of fact. The first task of the defendant is to isolate the separate allegations contained in each paragraph. After doing this, the next step is to decide how to respond to each of these allegations. That is, yes or no, or yes but, or I have no way of knowing, you prove it. Note that should the defendant decide to admit all the allegations contained in a particular paragraph, the practice has developed merely to indicate in his plea that he admits the entire paragraph. For the sake of accuracy, however, we suggest that even in such cases, defendants state that they admit all the allegations contained in a paragraph. Number 2.3.1 B3A. Drafting the different plea responses. When drafting a plea, you simply respond, in one of the ways discussed above, to each allegation contained in every paragraph of the plaintiff's particulars of claim or declaration. For example, should the defendant wish to admit all the allegations contained in paragraph 1 of the plaintiff's particulars of claim, it should be done as follows. At paragraph 1, the defendant admits all the allegations contained in this paragraph. Likewise, should the defendant wish to deny every allegation contained in a paragraph, it will be done as follows. At paragraph 2, the defendant denies all the allegations contained in this paragraph. When drafting a denial, the practice of adding the words "as if specifically transversed herein and the plaintiff is put to the proof thereof" should be avoided. Although many attorneys and advocates draft denials in this fashion, the effect of denying an allegation is that the plaintiff then bears the onus of proving that allegation. It is therefore unnecessary and cumbersome to add to a denial the obvious allegation that the plaintiff is put to the proof thereof. The usual form of drafting a confession and avoidance is as follows. At paragraph 3, the defendant admits the allegations contained in paragraph 3 of the particulars of claim, but avers that ... Here set out the additional facts which the plaintiff has omitted and which show the matter in a different light. Where an allegation is not to be admitted by the defendant, a reason must be given. Averring lack of knowledge, the usual reason, the response should be pleaded in the following manner. At paragraph 4. The defendant has no knowledge of the allegations contained in paragraph 4 of the particulars of claim, cannot admit or deny these allegations, and puts the plaintiff to the proof thereof. In this situation, the "puts the plaintiff to the proof thereof" phrase should be used. Once you have finished responding in one of these ways to the allegations in the plaintiff's particulars of claim, you should end off your plea with a prayer. Your prayer might look like this. Wherefore, the defendant prays for judgment in his favor, and the plaintiff's claim be dismissed with costs. Number 2.3.1 B3b. Dealing with all the plaintiff's allegations. When you are drafting a plea, it is important to bear in mind the provisions of Rule 22, Subsection 3 of the High Court Rules and Rule 17, Subsection 3 of the Magistrates' Courts Rules. Every allegation of fact in the combined summons or declaration which is not stated in the plea to be denied or admitted shall be deemed to be admitted. In other words, if you fail to deal with each and every fact in the particulars of claim or declaration, you run the risk that certain facts which you ought to have denied will be deemed to be admitted. Also bear in mind when drafting a plea the need to avoid the so-called negative pregnant. A negative pregnant is a negative expression which may imply or carry with it an affirmative proposition. A good example is the case of Brits versus Weidemann, referred to above. The summons in this case alleged that on a specific date on a particular farm, the defendant said the following defamatory and malicious words to the plaintiff. "Jy's 'n bloody skalle man en jy lieg," which translated to English means "you are a bloody rogue and a liar." In his plea, the defendant denied that he had used the words at the time and place alleged. The court held that the denial was a negative pregnant because you could read into the plea that the defendant had said the words, but not at the time and place alleged. The defendant should have denied using the words at all. Number 2.3.1 B3C. The consequences of not observing the rules when drafting pleas. In terms of Rule 22, Subsection 5 of the High Court's Rules and Rule 17, Subsection 6 of the Magistrates' Courts Rules, failure to comply with the provisions of the rules relating to pleas is deemed to be an irregular step. These subsections therefore have a similar role to that of Rule 18, Subsection 12 of the High Court Rules, or Rule 6, Subsection 13 of the Magistrates' Courts Rules in relation to particulars of claim. In such a case, the plaintiff is entitled to apply to court to have the plea set aside as an irregular step in terms of Rule 30, Subsection 1, or Rule 60A, respectively. Number 2.3.1 B3D. Material facts. Avoiding bare denials. Denials that do not comply with Rule 22, Subsection 2 of the High Court Rules or Rule 17, Subsection 2 of the Magistrates' Courts Rules are sometimes called bare denials. Both rules provide that the defendant shall clearly and concisely state all material facts upon which he relies. Obviously, whatever comprises a material fact in any situation will differ from case to case. Should the defense be based on a denial, no further facts need to be pleaded as the defense is based on a negative allegation, that is, a denial of the material facts averred by the plaintiff. This should be the case, for instance, where the plaintiff sues for defamation and the plaintiff denies the plaintiff's allegation that the defamatory words were uttered. Nothing more needs to be added. When the defendant's defense rests on a positive allegation, however, the material facts on which this allegation is based must be averred. This will always occur in a confession and avoidance situation. To use the defamation example again, should the defendant admit having uttered the allegedly defamatory words, he must go on to indicate both the nature of his defense and the material facts on which he relies. He may be able to claim that words were uttered on a privileged occasion, for instance, in which case the circumstances giving rise to the privileged occasion should be set out. He will also be obliged to set out the material facts if he intends to rely on a special plea. Erasmus lists several defenses which require the material facts to be pleaded, including the defense of fraud or mistake in a contractual claim, agency, compromise, contributory negligence, and estoppel. Number 2.3.1c, Special Pleas. Number 2.3.1c1, General Overview. A special plea is a plea which raises a special defense and is directed at an underlying legal problem in the plaintiff's case, rather than at the merits of the case. A special plea is procedural in character and either destroys or postpones the operation of the plaintiff's cause of action. Those special pleas which postpone the operation of the plaintiff's cause of action are called dilatory special pleas. Those special pleas which destroy the plaintiff's cause of action are called special pleas in abatement. Let us examine these two general types of special pleas. Number 2.3.1c2, Dilatory Special Pleas. Number 2.3.1c2a, Special Plea of Arbitration. Many contracts contain a clause stating that the parties will submit any disputes arising out of the contract to arbitration. If one of the parties to such a contract sues the other party to the contract without submitting the matter to arbitration, the party who is being sued may raise a special plea of arbitration. In other words, what the party raising the special plea is saying is, you cannot sue me yet, first you must take the matter to arbitration in accordance with our agreement. The requirements for the court to grant a stay in the action are, firstly, that the issue falls within the scope of issues required to be submitted to arbitration in terms of the agreement, and secondly, that the legal validity or existence of the contract is neither in issue nor the subject of the dispute. Number 2.3.1 C2b, Special Plea of Lis Pendens. A special plea of lis pendens may be raised in order to stay a particular action on the grounds that another action is already pending between the same parties, based on the same cause of action, in respect of the same subject matter. In other words, what the party raising this special plea is saying is, you cannot sue me for this, you are already suing me for the same reason regarding the same thing. The pending action may be in the same or in a different court. Whether or not the same cause of action exists is decided by examining the pleas as opposed to the evidence in both matters. In most respects, this plea is similar to the special plea of res judicata, discussed below, except that in the case of a special plea of lis pendens, the matter is still pending in both courts, whereas in the case of a special plea of res judicata, the matter has already been finalized and is then brought before court again. In the case of a special plea of lis pendens, the court has the discretion to stay the proceedings. Number 2.3.1 C2c, Special Plea of Premature Summons. When a summons is issued before the course of action is complete, the defendant may raise a special plea objecting to the premature summons. For example, a contract may stipulate that notice of breach is required before action may be instituted for breach of the contract. Should a plaintiff issue summons for breach of contract before giving notice of breach, his summons will be premature. The failure of a plaintiff to deliver a notice under Section 129, Subsection 1 of the National Credit Act prior to the issue of summons would also be susceptible to a special plea of premature summons. Another example of a premature summons would be one which is issued at the instance of a director of a company before a special resolution has been passed authorizing the action. Number 2.3.1 C3. Special pleas in abatement. Number 2.3.1 C3A. Special pleas of prescription. Every cause of action must be prosecuted within a certain period of time, failing which it will prescribe. Should the matter prescribe, the defendant will not be legally liable, even if all the plaintiff's allegations about the defendant's conduct are true. If the plaintiff institutes an action after his claim has prescribed, the defendant should raise a special plea of extinctive prescription. A special plea of prescription may be raised at any time and not only before litis contestatio. However, prescription may only be raised by the parties and not by the court meru motu, that is, of its own accord. Periods of prescription vary from case to case. It is therefore crucial for any attorney or advocate dealing with litigation matters to possess a good knowledge of the different periods of prescription. Prescription is every attorney's nightmare. Claims arising out of matters which have been allowed to prescribe comprise a high percentage of claims for professional negligence against attorneys. The first question an attorney should ask himself on being consulted by a client with a new matter is precisely when the client's claim is due to prescribe. The prescription date should be written in bold red letters on the front of the file. As a professional, an attorney has no excuse if he allows his client's claim to prescribe due to ignorance of the relevant legislation. In the section of this book dealing with letters of demand, we examine sections of various statutes which limit prescription periods in relation to specific claims against certain state bodies, including national, provincial, and local government bodies, and their employees. While these sections are focused on specific cases, prescription in general is dealt with by the Prescription Act 68 of 1969. It is essential for every attorney and advocate to understand this act fully. Let us examine some of the provisions of the Prescription Act. The Act makes reference to debts rather than claims. For the purposes of the Act, however, a debt comprises far more than a claim for money. In the context of the Prescription Act, it has been held that a debt has a wide and general meaning, and includes an obligation to do something or refrain from doing something. Furthermore, the term debt has a wider meaning than cause of action in the context of pleadings. However, the exact meaning of the term debt has been placed in so much doubt that by the recent decision in Makata versus Vodacom, in which the Constitutional Court found that a claim forcing Vodacom to commence negotiations with the claimant did not prescribe after 3 years. In reaching its decision, the Constitutional Court reasoned that a failure to meet a prescription deadline has the effect of denying a litigant access to a court. As Section 39, Subsection 2 of the Constitution requires legislation to be construed in a manner which is least intrusive on the right, debt should not be read to include every obligation to do something or refrain from doing something apart from payment or delivery. The periods of extinction prescription for various debts, that is, the periods after which the recovery of such debts can no longer be legally enforced, are set out in Section 11 of the Prescription Act. Number 1. For most debts, the period of prescription is 3 years. Section 11, subsection D provides that, except where an Act of Parliament specifically provides otherwise, the period of prescription of any debt is not specifically mentioned in Section 11 is 3 years. Number 2. In terms of Section 11, subsection C, if the debt arises from a bill of exchange, such as a check or other negotiable instrument, or from a notarial contract, the period of prescription is 6 years, unless a longer period applies in respect of the debt in question in terms of paragraphs A and B of Section 11 discussed below. Number 3. In terms of Section 11, subsection B, the period of prescription is 15 years in respect of any debt owed to the state, and arising out of an advance or a loan of money or a sale or lease of land by the state to the debtor, unless a longer period applies in respect of the debt in question in terms of paragraph A of subsection 11 discussed below. In terms of Section 11, subsection A, the period of prescription is 30 years in respect of any debt secured by mortgage bond, any judgment debt, any debt in respect of any taxation imposed or levied by or under any law, any debt owed to the state in respect of any share of the profits, royalties, or any similar consideration payable in respect of the right to mine minerals or other substances. Note that in the case of a surety's accessory obligation, should the principal debt be kept alive by a judgment, the accessory obligation also continues to exist for the normal period provided for judgment debts. Section 12 of the Prescription Act sets out when the period of prescription begins to run. Usually it will begin to run as soon as the debt is due. A debt is not deemed to be due until the creditor has knowledge of the identity of the debtor and the facts from which the debt arose. Note that no specialist legal knowledge is required on the part of the creditor. For example, assume that the creditor was assaulted by a policeman. As long as the creditor is aware that he was assaulted and was not, for instance, knocked unconscious, resulting in complete memory loss, and that the person who assaulted him was a particular policeman, prescription will start running. The fact that the creditor may be unaware that he has a legal claim and the precise nature of that claim does not prevent prescription from running. Note further that the creditor will be deemed to have knowledge of the identity of the debtor and of the facts from which the debt arose if he could have acquired such knowledge by exercising reasonable care. For example, assume that the creditor in the above example is unaware of the name of the policeman who punched him, but instead of making reasonable inquiries to find out the policeman's name, he simply sits back and does nothing. In relation to the creditor's potential civil action against the policeman, prescription will start to run from the time the creditor ought reasonably to have established the policeman's identity. In certain cases, the debtor may willfully prevent the creditor from becoming aware of the existence of the debt. In such cases, prescription will only begin to run when the creditor becomes aware of the existence of the debt. Note also that the creditor must have actual awareness of the debt or at least a justified belief in its existence, which can be inferred from the surrounding circumstances. An unsupported belief or a suspicion, even if it happens to be correct, is insufficient to allow prescription to commence. In terms of Section 13 of the Prescription Act, the running of prescription may be delayed where, number 1, the creditor is a minor, now a person younger than 18, or is insane, or is a person under curatorship, or is prevented by superior force, including any law or any order of court, from interrupting the running of prescription by the service of process on the debtor. Number 2, the debtor is outside the Republic. Number 3, the debtor and creditor are married to each other. Number 4, the debtor and the creditor are partners and the debt is a debt which arose out of the partnership relationship. Number 5, the creditor is a juristic person and the debtor is a member of the governing body of such juristic person. Number 6, the debt is the object of a dispute subjected to arbitration. Number 7. The debt is the object of a claim filed against the estate of a debtor who is deceased, or against the insolvent estate of the debtor, or against a company in liquidation, or against an applicant under the Agricultural Credit Act number 28 of 1966. And number 8, the creditor or the debtor is deceased and an executor of the estate in question has not yet been appointed. In such cases, if the period of prescription would have been completed before or on or within 1 year after the day on which the relevant impediment referred to in these cases ceased to exist, the period of prescription will be completed only 1 year after the day on which the impediment ceased to exist. In terms of Section 14 of the Prescription Act, the running of prescription may be interrupted by an express or tacit acknowledgement of liability by the debtor. In running of prescription, the running of prescription starts afresh on the date of the acknowledgement. For example, assume that a debt has been outstanding for 2 years and 364 days and is about to prescribe. At that stage, the debtor pays a small amount to the creditor and states that he will pay the rest of the debt when he can afford it. This amounts to a tacit acknowledgement of liability, and the 3-year period of prescription starts to run afresh from the dates on which the payment was made to the creditor. Each time an installment is paid on a debt, prescription starts to run afresh. In terms of Section 15 of the Prescription Act, the running of the period of prescription is interrupted when the process whereby the creditor claims payment of the debt, that is, summons or notice of motion, is served on the debtor. Note that a letter of demand does not count as a process. It is only by serving a summons or notice of motion on the debtor, thereby instituting an action or application, that the running of prescription can be interrupted. Note further that the issuing of a summons or notice of motion by the registrar or clerk of the court is not sufficient to interrupt prescription. The documents must actually be served on the defendant or respondent before interruption occurs. An attorney should therefore ensure that there is enough time to issue and serve the summons or notice of motion before the prescription date arrives. It is wise to remember that the sheriff of the court is often unable to secure proper service on the first attempt, because the defendant or respondent is not at home, for instance, when the sheriff arrives to serve the document. An attorney should allow for such delay, because he is ultimately responsible for making sure that the matter does not prescribe. Finally, note that unless the debtor acknowledges liability, the interruption of prescription by the service of process shall lapse, and the running of prescription shall not be deemed to have been interrupted if the creditor does not successfully prosecute his claim under the process in question to final judgment, or if he does prosecute his claim but abandons the judgment or the judgment is set aside. Number 2.3.1 C3b. Special plea of misjoinder and non-joinder. A special plea of misjoinder may be raised where a party who should not have been joined to an action has been joined. For example, Mr. Sipu Zulu, who stays at 23 Kudu Lane, Durban, is cited as the defendant in an action for damages resulting from a motor vehicle collision, but knows absolutely nothing about the collision in question. There is another person by the name of Sipu Zulu who stays at 32 Kudu Lane, Durban, and it transpires that it is that Mr. Sipu Zulu who should have been sued. The first, Mr. Sipu Zulu, is entitled to raise a special plea of misjoinder. A special plea of non-joinder may be raised where a party who should have been joined in an action has not been joined to the action. If a person has a direct and substantial interest in the matter, or if the order the court is being asked to make is likely to prejudice somebody, then that person must be joined. Persons in this category would include co-owners, joint contractors and partners. Where such a plea is upheld, the action is not dismissed but is stayed until the proper party has been joined. Number 2.3.1 C3C Special Plea of Res Judicata. A special plea of res judicata may be raised if the defendant is able to show that the point in dispute has been adjudicated upon already between the parties. In other words, the plaintiff's claim has been heard previously by a court that has given a final judgment in the matter. The previous court is functus officio and cannot hear the matter again. If the plaintiff is unhappy with the previous court's decision, his remedy is to either take the matter on appeal or on review, not merely to begin a fresh action in the same or in some other court. A matter is res judicata if a competent court has previously reached a final judgment in a matter based on the same cause of action and involving the same parties. What this amounts to is that the order granted in the previous hearing must be final and definitive of the issues raised by the same party in the current matter. This is ascertained by examining the pleadings as opposed to the evidence led at the previous hearing. When considering what constitutes the same cause of action for the purpose of res judicata, issues that ought to have been raised in earlier proceedings but were not raised are also included. Parties are required to bring their full case, this requirement being known as the once and for all rule. A special plea of res judicata in a civil case may be compared to a plea of autrefois convict or autrefois acquit, previously convicted or previously acquitted, that is, double jeopardy, in a criminal case. Once a criminal accused has been either convicted or acquitted of criminal offence, he may not again be tried for that same offence. Note that if the court in a civil case gives a judgment of absolution from the instance, the plaintiff is generally entitled to bring a fresh action based on the same facts, without having to fear that he will be met by a special plea of res judicata. Number 2.3.1 C3D Special Plea to Jurisdiction. If the plaintiff brings an action in a court which lacks jurisdiction, the defendant may raise a special plea of lack of jurisdiction. Number 2.3.1 C3E Special Plea of Non-Locus Standi in Judicio. If the plaintiff brings an action and lacks a real and substantial interest in the matter, that is, locus standi, or does not establish locus standi under the extended grounds in Section 38 of the Constitution, the defendant may raise a special plea of non-locus standi in judicio. Number 2.3.1 C4 Drafting a special plea. A special plea is usually raised at the start of the defendant's plea in a separate section with the heading Defendant's Special Plea. A simple statement follows to the effect that the defendant is raising a particular special plea. Thereafter, the facts upon which that special plea is based are set out. For example, a special plea of prescription may contain the following. Number 1. The date upon which the plaintiff became aware or ought reasonably to have become aware of the facts upon which his cause of action is based. Secondly, the dates on which the summons was served on the defendant. Number 3, the period of extinctive prescription applicable to the claim in question. Number 4, the fact that the plaintiff's claim had prescribed by the time the summons was served on the defendant. And lastly, a request for judgment against the plaintiff with costs. In response to such a plea, the plaintiff could argue perhaps that the dates alleged by the defendant were wrong, or that the plaintiff could not reasonably have been expected to be aware of the facts upon which his cause of action was based on the date alleged by the defendant, or that the running of prescription was somehow interrupted. There is no uniform practice with regards to the need to plea over on the merits, but it seems that all defenses that the defendant intends to raise must be raised at the same time. This means that although there is no need to plead over on the merits if the defendant intends to rely solely on a special plea, no further opportunity will be afforded to plead over should the special plea fail. This applies in both the High Court and the Magistrates' Courts. Number 2.3.1 C5. Separate hearings for special pleas. Whilst there is no longer provision in the Magistrates' Courts rules for a separate hearing at which the matter might be resolved without the need for an expensive and time-consuming trial on the merits, the parties may make use of a Section 54 pre-trial conference in order to raise the prospect of a separate hearing at which a special plea can be adjudicated. At the pre-trial conference, the magistrate may use the powers afforded by Section 54, Subsection 1e, or alternatively by Rule 1, Subsection 3, to order such a hearing. High Court Rule 33, subsection 4 provides that if in any pending action it appears to the court mero motu that there is a question of law or fact which may be decided conveniently either before any evidence is laid or separately from any other question, the court may make an order directing the disposal of such question in such manner as it may deem fit, and may order that all further proceedings be stayed until such question has been disposed of. And the court shall, on the application of any party, make such order unless it appears that the question cannot conveniently be decided separately. A party requesting such a hearing must bring a formal application and show that it is convenient to dispose of the particular question of law or fact separately. The question itself may not be disposed of at the hearing of the application, but at a future hearing should the application be granted. Here, the court will consider whether the appropriate circumstances exist in which a separation would facilitate the convenient and expeditious disposal of litigation. The rule allows for a broad range of issues to be heard, both of fact and law. However, a court is likely to agree only to deal with issues which, if resolved, will save costs or finally determine the matter. Besides the use of the rule for special pleas which relate to questions of law, it is frequently used to determine questions of fact in medical negligence matters. For example, where the court may order that the issues of liability and quantum are separated. If the plaintiff is ultimately unsuccessful in proving the defendant's liability, both parties would have been spared the costs of leading evidence in the issue of quantum. A special plea may be brought in terms of this provision. Note that it is the duty of an attorney to consider whether or not the use of this procedure may avoid unnecessary delay of costs. Sorry about that. Okay, number 2.3.2, counterclaims. Number 2.3.2a, overview. A counterclaim is a claim brought by the defendant against the plaintiff. You may think of a counterclaim as a separate action which, for the sake of convenience, runs together with the existing action. The plaintiff's claim is referred to as the claim in convention, and the defendant's counterclaim is the claim in reconvention. All the normal rules for drafting particulars of claim apply to counterclaims. The same time limits apply to counterclaims as to particulars of claim, but there is no need for the plaintiff to enter an appearance to defend in respect of the counterclaim. Summary judgment, which is discussed in detail later in the book, cannot be obtained in respect of a counterclaim. The counterclaim may be linked to the plaintiff's claim in the sense that it arises out of a set of related facts, but this need not necessarily be the case. Assume, for example, that the plaintiff sues the defendant for the price of goods sold and delivered. The defendant counterclaims on the grounds that the goods delivered to him were defective and caused damage to the machinery in his factory. In this case, a link exists between the claim and the counterclaim. However, the counterclaim may be completed unconnected to the transaction which gave rise to the plaintiff's claim. For example, the defendant may allege that he was assaulted by the plaintiff because of a personal dispute between them. In either case, it makes sense for the claim and the counterclaim to be dealt with at the same time. Normally, the respective parties to the claim and the counterclaim are the same, but it has been held that a defendant sued in his personal capacity may, in a representative capacity, counterclaim against the plaintiff. The converse is not true. A counterclaim cannot be brought against a plaintiff in a different capacity from that in which he sues. If the cause of action for the counterclaim is such that the defendant has a valid cause of action against the plaintiff as well as another person or persons, High Court Rule 24, Subsection 2, and the Magistrates Courts Rules 20, Subsection 2, allow the defendant to take action against such a person or persons as well as against the plaintiff by means of the counterclaim. This will only be allowed with the leave of the court, in such manner and on such terms as the court may direct. In terms of High Court Rule 24, Subsection 3 and Magistrates Courts Rule 24, Subsection 3, if the defendant has been given leave to counterclaim against the plaintiff plus another person or persons, then the title or citation of all further pleadings must be altered so as to reflect the additional parties. Both the claim and counterclaim should be heard at the same hearing unless they arise from completely different sets of facts, in which case they may be tried separately. The resulting judgments should nevertheless be given pari passu or simultaneously in the magistrates' courts. This is also the approach in the High Courts, particularly in view of the danger of conflicting results if the matters are dealt with piecemeal. However, the superior courts have been known to use their inherent jurisdiction to grant default judgment on a claim in reconvention. Number 2.3.2b. Procedure. Magistrates Courts Rule 20 is based on High Court Rule 24. In terms of High Court Rule 24, Subsection 1 and Magistrates Courts Rule 20, Subsection 1, the defendant must deliver his counterclaim to the plaintiff together with the plea to the plaintiff's claim in convention, that is, the plaintiff's claim as set out in his particulars of claim or declaration. If the defendant does not deliver his claim in reconvention together with his plea, the rule provides that the plaintiff may consent to it being delivered at a later stage. If the plaintiff refuses to consent to late delivery of the counterclaim, the court may be requested to allow it. The counterclaim itself should be set out in all respects like a set of particulars of claim, and must give particulars of all the material facts of the claim in compliance with the rules that pertain to particulars of claim. The claim in reconvention may either be set out in a separate document or else included in a separate section of the plea which is headed Claim in Reconvention. It is not necessary to cite the parties in full in the claim in reconvention. Instead, the first paragraph of the claim in reconvention may simply state the plaintiff in reconvention is the defendant in convention, that the defendant in reconvention is the plaintiff in convention, and that for the sake of convenience the parties are referred to as before. In other words, the plaintiff in convention remains the plaintiff and the defendant in convention remains the defendant, even for purposes of the claim in reconvention. Provided that it is based on the same transaction, the defendant's claim in reconvention will often be based on many of the same averments that are set out in the plaintiff's particulars of claim or declaration. In such a case, it is not necessary to repeat all these allegations in the counterclaim. The allegations to be repeated may simply be incorporated into the claim by reference to the relevant paragraphs in the particulars of claim or declaration. A clause in the counterclaim providing for such incorporation might read as follows. The allegations contained in paragraphs 5, 6, and 7 of the plaintiff's particulars of claim are hereby incorporated into the defendant's claim in reconvention. Of course, the contents of averments that are incorporated from the particulars of claim would be common cause to the parties. Allegations contained in the defendant's plea may also be incorporated into the defendant's claim in reconvention if the claims in convention and reconvention arise out of the same set of facts. This situation aside, however, the defendant should avoid mixing the contents of the plea and the counterclaim. The two are distinct and should be kept separate to make it easy for the plaintiff to respond. High Court Rule 24, Subsection 5 and the Magistrates Courts Rule 20, Subsection 8 both provide that failure to observe the provisions of Rule 24 and the High Court Rules or Rule 20 in the case of Magistrates Courts is deemed to be an irregular step in terms of Rule 30 or Rule 60A respectively. Number 2.3.2c. Counterclaims in the Magistrates Courts. As indicated above, counterclaims in the Magistrates Courts are dealt with by Magistrates Courts Rule 20, which is almost exactly the same as the corresponding Rule 24 of the High Court Rules, except for special provision made in Rule 20, subsections 5 to 7, for a situation in which the defendant's counterclaim exceeds the jurisdiction of the Magistrates Courts. A defendant in an action in the Magistrates Courts who wishes to bring a counterclaim which exceeds the jurisdiction of the Magistrates Courts should apply to the court in terms of the Magistrates Courts Rule 20, subsection 5. To first declare that the counterclaim exceeds its jurisdiction, and secondly, to stay the action under Section 47 of the Magistrates Courts Act. Notice of the application may be delivered together with the counterclaim, or within 5 days after the counterclaim has been delivered. If the court is satisfied prima facie that the defendant has a reasonable prospect of obtaining a judgment on his counterclaim in excess of its jurisdiction, it will stay the action in the magistrates' courts for a reasonable period. This will enable the defendant to institute action for the amount of his counterclaim in the High Court. Once the defendant institutes action in the High Court, the plaintiff is entitled to counterclaim in the High Court for the amount of his claim in the original Magistrates' Court's action. In other words, the claim and counterclaim in the Magistrates' Courts will be dealt with in the High Court, the only difference being that the defendant will become the plaintiff. The claim will become the counterclaim and vice versa. Various mechanisms are set out to prevent defendants delaying matters by not proceeding with the High Court action. If a defendant who wishes to bring a counterclaim exceeding the jurisdiction of the Magistrates' Courts fails to apply for the action in the Magistrates' Courts to be stayed, the court may dismiss the counterclaim unless the defendant abandons, in terms of Section 38, sufficient of the counterclaim to bring it within the jurisdiction of the Magistrates' Courts. Number 2.4. Step 4. Replication and possible subsequent steps. Number 2.4.1. Replication. The plaintiff may respond to the defendant's plea by means of replication. Magistrates Courts Rule 21 is virtually the same as Rule 25 of the High Court Rules, and the procedure for replication in both courts is the same. Generally speaking, a replication is only necessary if the defendant has raised new averments in his plea, which the plaintiff cannot allow to go unchallenged. Usually, such new averments will be made by the defendant as part of a plea of confession and avoidance, in which the defendant admits certain of the plaintiff's averments but makes further new averments which show the plaintiff's original averments in a different light. It may then be necessary for the plaintiff to counter the new averments made by the defendant with further averments of his own, which will be contained in his replication. In the majority of cases in practice, a replication is not necessary since the defendant either admits or denies the different allegations made by the plaintiff, and does not raise new averments which require a response on the part of the plaintiff. It is important to note that the plaintiff may only plead such fresh facts in his replication as are called for by the defendant's plea. The plaintiff may not, for example, use his replication as an excuse to introduce a new cause of action or to increase the size of his claim. This kind of replication or reply is known as departure, and the defendant may bring an application to strike out the replication or accept to the replication. In terms of High Court Rule 25, Subsection 1 and the Magistrates Courts Rule 21, Subsection 1, the plaintiff must deliver the replication to the defendant within 15 days, court days, after receiving the defendant's plea. In terms of Rule 26 of the High Court Rules, if he does not do so, he will be barred and may not do so later. While previously there was no equivalent in the Magistrates Court's rules for the automatic barring of late pleadings, new Rule 21b now makes provision for a notice of bar in respect of all pleadings. Rule 21b provides that any party failing to deliver the pleading referred to in a notice within the time therein required or within such further period as may be agreed between the parties, shall be in default of filing such pleadings, and ipso facto barred. Number 2.4.2 Possible steps after replication. In some cases, it may be necessary for the defendant to file a rejoinder to the plaintiff's replication, and then for the plaintiff to file a surrejoinder to the defendant's rejoinder. The defendant may then file a rebuttal to the plaintiff's surrejoinder, and the plaintiff may reply with a surrebuttal to the plaintiff's rebuttal. It is only when new averments are made in the previous pleading that it is necessary to respond by means of any of the above pleadings. In practice, therefore, it is only in exceptional cases that it is necessary to file rejoinders, surrejoinders, rebutters, and surrebutters. As each pleading is filed, it becomes increasingly unlikely that fresh issues will emerge to which the opposite party is required to respond. The result is that while replications and replies are infrequent in practice, rejoinders, surrejoinders, rebutters, and surrebutters are rare in the extreme. Number 2.5. Step 5. Close of pleadings. Litis contestatio. In general terms, it may be said that the purpose of pleadings is to define the issues in dispute. Once the issues in dispute have been defined, the pleadings close. After that, the preparations for the trial begin. The exact time at which the pleadings close is important because this is the moment of litis contestatio. In other words, the moment when issue is joined between the parties. The effect of litis contestatio is to freeze the plaintiff's rights at that moment. For example, if a plaintiff who is claiming non-pecuniary damages for pain and suffering, loss of amenities of life, and disfigurement happens to die before litis contestatio, his claims die with him. If he dies after litis contestatio, however, these claims are transmitted to his estate. A recent judicial decision appears to have unsettled this rule. In the precedent-setting decision of Nkandla and others versus Harmony Gold Mining Company Limited and others, the claimants sought and were granted certification of two classes of plaintiff to pursue a class action against certain South African mining houses. In addition to certification, the claimant sought a declaration that any claim for general damages brought by a claimant against the mining companies would be transmissible to his estate should he die before the litigation reaches the stage of litis contestation. The concern arose inasmuch as a number of the claimants were terminally ill and a possibility existed that they would not survive to the stage of litis contestatio. The Gauteng Local Division, Johannesburg, held that the law which prohibits the transmissibility of general damages pre-litis contestatio fails to reflect the boni mores of society, failed to protect the claimant's constitutional rights to bodily integrity, and required development in the light of the spirit, purport, and objects of the Constitution. The court held the common law has to be developed to allow for the claims of general damages to be transmissible to the estate or executor of a deceased mine worker, even though the stage of litis contestatio had not been reached at the time of his death. Also, the development is necessary in the light of the court's general duty to do justice by the persons affected by its orders. The development should not be restricted to the case where the plaintiff has died pre litis contestatio. It should also apply to the case where the defendant or potential defendant has died pre litis contestatio, as the same principle as those that apply to plaintiffs apply to them. The court accordingly held that the common law should be developed as follows. Number 1. A plaintiff who had commenced suing for general damages but who has died from whatever cause before his claim has reached the stage of litis contestatio will be entitled to continue with such action notwithstanding his death. Number 2. Such action shall be for the benefit of the estates of the person. And number 3, the development is not restricted to class actions only, but all applies to claims. It remains to be seen whether this aspect of litis contestation will continue to have a place in South African law after this judgment. Currently, High Court Rule 29 and Magistrates Court Rule 21A set out the following instances in which pleadings shall be considered closed. Number 1. If either party has joined issue without alleging any new matter and without adding any further pleading. Number 2. If the last day allowed for filing a replication or subsequent pleading has elapsed and it has not been filed. Number 3. If the parties agree in writing that the pleadings are closed and such agreement is filed with the registrar. Or number 4, if the parties are unable to agree as to the close of pleadings and the court, upon the application of a party, declares them closed.